Oh, okay. Let's continue then.
Is it please the court, my lord?
Yes.
My lord, I won't be long. I'm going to be very short, and I will try not to conflate issues.
Okay.
The situation is very succinct, my lord. We're not saying that the court should actually not listen to the recording by Mrs. Granger. However, what we are putting before court, my lord, is the fact that in a situation where the admissibility of electronic evidence is at issue, then the court must hold a trial within a trial to determine the admissibility of such piece of evidence. That is just a precursor, my lord. It will then, only after the court has made a ruling that such evidence gets to be admissible, then the court will then go on and listen to such recording, my lord.
Yeah, but you're correct, Mr. Mnisi.
Yes.
But the fact of the matter is, you see, we started with accused number 1 when he contested the admissibility of the alleged confession.
Yes, my lord.
Before Mboto. And the court, because as you know, the accused are charged with conspiring in the pursuance of a common purpose.
Yes, my lord.
So maybe it will be tautologous if I say I obviously did make a ruling that a trial within a trial must be held. Now that we are dealing with the interception of communications in terms of the act,
Yes, my lord.
we must hold another trial within a trial. We are holding a trial within a trial. It's a continuous exercise, okay?
That is the procedure, my lord. I think the court has already been referred to the Mutata case.
Yes, yes.
Just a very brief about what happened at Mutata case. The court that was hearing the matter at the regional court in Joburg had a trial within a trial to decide on the admissibility of the evidence that was contested then, which was the recording from the cell phone and all those gadgets. Mr. Judge Mutata, and then the final ruling of that court was to the effect that there's nothing wrong in the court listening to that audio hearing. That is after a trial within a trial was then held. Mr. Mutata, Judge Mutata was not happy with that decision, and then he took it on appeal. On appeal, unfortunately, things did not go his way. That is basically what we're saying here, madam, that there should be a precursor. There should be a precursor to a hearing of this audio by the court.
What is the precursor? What is the precursor, according to you?
In other words, we should not put the cart before the horses.
And the
horses should always be in front.
What are the horses? Using that example, the cart before the horses. That is the precursor you're talking about.
What I'm saying, my lord, the precursor to what is happening now is for the court to have a trial within a trial to decide on the admissibility.
We're having that.
And that is very different, my lord. We are having a trial within a trial to decide on the admissibility of the confession, the pointing out, and the other document as well, but not specifically with regard to now the new information or evidence that is now contained. So
we must have two trials within a trial.
That is what the process is supposed to be, my lord.
I told you it's tautologous. Because we are addressing all the exigencies of the trial within the trial. The pointing outs, the alleged confessions, everything.
It is unfortunate, my lord, that as we are holding this trial within a trial, another aspect comes out which would necessitate a trial within a trial to decide that very aspect that has come out in the process of a trial within a trial.
Yeah, fine, I hear you.
Which is the audio. And the reason, simply because, my lord, I'm saying that the court needs to hold a trial within a trial to decide the admissibility of this audio recording, mentioned in the Electronic and Communications and Transaction Act 2002. I think they are there Section 15 of the Act, which says as follows, or aptly says as follows.
Okay, I hear you.
Yes.
Okay, maybe because you were not here at the beginning of the arguments.
Yes, my lord.
I am at the moment
Yes.
holding a trial within a trial
Yes.
regarding the admissibility of the audio recording which was made by Mrs. Cronje, to the effect that is it admissible in evidence or is it not? That's it. You want that?
The process of holding a trial within a trial, my lord, is to call witnesses, is to put the grounds on why that evidence is contested.
I know.
I'm not so sure whether that happened, my lord. I'm not so sure whether there's a witness who has already testified with regard to the authenticity, the originality,
But okay,
the storage
at
and
the moment,
everything of that audio
at the
video.
moment,
Yes, my lord.
as I view it,
Yes, my lord.
it's interconnected, but in essence,
Yes.
this court now, in terms of Section 145C of the Criminal Procedure Act,
Yes, my lord.
it's deciding a matter of law,
Yes.
whether, as a matter of law, those audio recording made by Mrs. Cronje is admissible in evidence. Now, that is the precursor. If I find that it is admissible, that's not the end of the story.
Yes, my lord.
You see,
Yeah. That,
then the onus
you,
is
my
on the state to proceed and prove whether, in fact, the other aspects, they've proven them.
I'm well aware, my lord,
Okay.
that at the end of it all, the fact that the court has ruled that the audio recording is admissible
Or not.
it's not, or not, let me say, if the court rules that it is admissible, that is not the end of the story.
Yeah,
I
that
think
aspect,
that aspect has been
strictly
touched
speaking,
upon
you're right.
aptly by
That aspect,
my
strictly
colleague. my
speaking,
lord. Yes.
it's not evidence which determines whether
Yes.
this court is holding a trial within a trial. Are you with me?
I did not get that, my lord.
The decisiveness of this court finding that the evidence regarding the tape recording is admissible, right?
Yes, my lord.
The trial within a trial is still continuing because that evidence came out during the evidence of Mrs. Cronje,
Yes,
who
ma'am.
was testifying in a trial within a trial pursuant to Section 217. That's-
This, from where I'm standing,
Yeah.
my lord, I think these are two processes that,
Yes, they are, you're right.
that are not the same.
Okay, fine.
Because the
Okay.
first trial within a trial has got to do with
The statement.
the admissibility of the statement
Right.
that were allegedly made by the accused.
Right.
And what I'm submitting now is within that trial, within a trial, in other words, within that first trial within a trial, something came up
Yes.
which then necessitates
Yes.
a trial within a trial in the context of the first trial within a trial, which is the admissibility of the recordings.
Okay, fine. I can declare that we are also conducting a trial within a trial regarding the admissibility of the audio recordings. Does that cure your problem?
If what is happening now, my lord, then
Yeah.
it's a trial within a trial, then I'm not in a position to take the matter any further.
It's
Because
interconnected. That's why I was saying you're not holding a trial within a trial in respect of one aspect. We are even holding a trial within a trial of the pointing out, which your learned colleague will probably have to lead evidence on after this issue regarding whether the audio recordings are admissible or not.
Yes, my lord. As I'm saying,
Yeah. No, you're correct.
If what is happening now is a trial within a trial, then I'm not in a position to take the issue.
Yeah,
any
because
further,
I can't
that was actually my point.
Okay, fine. I agree. That's why Mr. Ngome Zulu
Yes.
talks about rights which have been infringed by Ms. Cronje,
Yes.
and that she did not alert his client about the fact that she is recording
Yes,
the
my lord.
pro forma
Yes.
questions and answers.
Yes.
And consequently, he says those rights in section 35(5),
Yes.
namely of unlawfully acquired evidence, which is to be excluded, and evidence which, if it's admitted, it will bring the administration of justice into disrepute. Am I quoting you correctly, sir?
That's correct.
Yeah. So it's intertwined. Yeah, but you're correct.
Then I may not take this point any further, my
Okay,
lords.
fine.
I'll rest my case. my
Okay.
lords. Thank